May I please, Your Lordship?
Yes.
So I beg to mention item number 11. Item number 11, the matter may be fixed on 12th October, my lord.
12,
12th October, October 12.
you're for the petitioner?
I'm the petitioner, my lord. Yes, respondent number is now leave of absence. He's, yes,
You have taken consent?
yes, consent I have taken.
Okay, sir.
I know.
Well, Lordship, I beg to mention item number 3. Lordship, in this matter, we require to file the counter affidavit. I am for the sole respondent. Better may be taken.
Respondent.
Yes, Lordship. Better
Who's
may
the
be.
appellant?
Loss.
You're for the
Loss. Lordship, there is an interim order, Lordship.
interim order.
Loss.
After 2 weeks,
After 3 weeks.
3 weeks.
Oh, Lordship.
May I please, Your Lordship? I beg to mention item number 4. Your Lordship, yes, Your Lordship. The matter may be fixed on 26 of this
You're for
month.
the petitioner.
Yes, Your Lordship. Much obliged.
My lord, I beg to mention item number 9, my lord. I have taken consent from others. My lord.
You're for the petitioner? You're for the petitioner?
No, ma, I'm respondent, my lord.
You're for the petitioner?
Yes, interim order.
Interim also.
My lord, matter may be taken after 3 weeks, my lord.
3 weeks.
Yes.
With the consent of the others.
Obliged.
May my lord,
Yes.
this application is filed by
Oh, issue notice to respondent number 2. With register ready as well as usual process, returnable within 2 weeks. The petitioner is to take steps within 3 days.
much obliged.
May I plead, madam? Lordship, may I just brief this matter before starting? In fact, this petitioner is, in fact, there is a issue of separation of or demarcation of ancestral land between the petitioner's father and the respondent number 5. And then there was an agreement between the two families. In fact, they are son of the land which is to be demarcated is an ancestral land. It was left by the their father, the spot Taken Rugbo. So, issue in this is that there was a series of meetings between the family members and some neutral bodies, but then that the land is around maybe 5 or 6 ancestral properties which was left out. They decided, as per the agreement, that first we decide which land will belong to whom, especially the petitioner's father and then respondent number 5. And what happened was there was an agreement. I will just take to the letter. I will go to the agreement. In the agreement, there is 2 conditions. The agreement says that after the proper demarcation, there should be an execution before the first class magistrate by the petitioner's father and then respondent. But then what happened in this issue? The respondent, he started erecting some iron post in some of the area which was not properly demarcated. Then what happened? Even the respondent's petitioner's father also, I will just go to that document. He also issued a legal notice and then letter to the deputy commissioner saying that this area is not been demarcated. Why you are doing erection in that matter? So what happened? The petitioner, who is the son of the respondent's brother's son, he went and just say that when there is an agreement, so you should not do demarcation unless it is registered or unless it is properly demarcated, then you should not do this activities, because my father has informed that. On that basis, there was no any fight. There's only discussion with his uncle in the field. The place is called a Tajum. The location is called a Tajum. It's a 5th mile. He just had a discussion with him because in 2 occasions, he also informed him that you should not erect. And then only his father issued legal notice. And then what happened was that the surprise was that his uncle lodged a FIR saying that he tried to trespass in his private plot. Whereas this private plot, which,
Which the fire,
yes, I will just go to the FIR. FIR is my, you'll also in a page, it start from page 78. Page 78. It's starting from the page 78, and I will just take to the type 1, your lordship. Is in page 80. May I read that one?
80,
Yes, it is a type 1. May I read? The officer,
83,
yes. 70, 80, madam.
80.
80, madam.
Yes.
Yes, may I read that? 80. The first, may I read the first information content to the officer in charge, Pasigat Police Station, is Siang District, Arunachal Pradesh, dated 28/02/2021. The first information report. Sri Kaling Dorup is the respondent number 5, age about 59, yes, son of late Taken Rukbo, resident of village Yakpo, POPS Pasigat, is Siang District, Arunachal Pradesh. Do we hereby most respectfully beg to inform you that at around about 12:38 p.m. that is 28/02/2021, when he was erecting boundary angle post demarcated by neutral bodies over my lane situated at 5th mile area. All of a sudden, one Sri Simul Doruk is the petitioner here, and son of the uncle of this complainant, son of Tamon Doruk. Tamon Doruk is the brother of the complainant, my lord. You say. Resident of Yagbo village, PS Pasig, is in relation of son, my elder son, Sri Tamun Duruk, most illegally trespassed into my plot of land situated at 5th mile area, thereby scolding, abusing me, and disturbing in doing the construction work and boundary angle post, and also threatened my labor. That Sri Simul Duruk also pushed and pulled. The allegation is only push and pull me and attempted to assault me in presence of Sri Oshuk Legu and Sri Talum Taing, Sri Kadum Doruk. Sri Simul Duru also on earlier occasion twice on dated 19/11/2022 and 20/11/2023 and chased away my labors, and thereby 20 knots of angle post got lost from the spot and 35 bags of cement got damaged, and also I paid a sum of rupees 60,000 to the said laborer as an advance payment for the boundary angle post construction work. But the said work could not be completed, and the Simul Duru threatened and chased them away, for which I suttered huge loss to tune of 60,000 rupees. For such illegal act of Sri Simul Duru, it is pertinent to state that here that as per the deed of amicable settlement 21/8/2020, and as per the demarcation dated, so he mentions the demarcation dated 21/8/2020 and 19/10/2020. You may mark this date because it is of 19/10/2020 and 21/8/2020, and prepared by neutral body for the respective plots of land as per Dusum Kebang decision dated 22/1/2021. In between me and my elder brother Sri Tamun Doru, we have reached out to an amicable settlement with regards to the division of land property. Therefore, Sri Simul Doru has no way right to claim object against me pertaining to my share of, that's important, my lordship, share of my landed property. Therefore, I request you to look into the matter and take immediate necessary action against the Sri Simul Duru, son of Sri Tamun Duru, resident of village Yapgo, POPS Pasigat, district Isian, for criminal trespass, criminal trust intimidation, attempting to assault me, destroying my angle post and cement, and obstruction me and my laborers in doing construction work over the lane, and further to restrain him from further attempt to enter into my said lane and from doing my illegal act over my lane and against me, and also to book him as per the relevant provisions of law and punish him as per the law, the act for which I shall be highly obliged to. Yours faithfully, Kalingdo. And then he has enclosed is the agreement. Your lordship may please to see, one is the amicable partition. I will just take to that relevant paragraph of the amicable partition. Amicable partition of the landed property between Tamun Duruk and Kaling Duruk. That it, your lordship may note this one. This is an important date, 21 August 2020. There was an amicable agreement, but there was a condition, your lordship. Family agreement, land portion dated 10
Which
to.
number?
Yes, ma'am. I will, agreement, yes, I can take to the agreement, your lordship, page 35. Page 35. Page 35 is the agreement between the two parties, Tamun Doruk and Kaling Doruk, because they are the successor of that, their father, Taken Doruk. And then I will just take to the important relevant point is page 37. The land which is being disputed in page 37. Cell number 2, sub clause 1. Cell number 2, sub clause 1. That is the plot land measuring 21,000 to 2,12,905 square meter. 2.2129 hectares covered by LPC memo number such and such, 21 July 1999, situated at 5th mile. The location is a 5th mile, and that is that location also called as Tajum. Pasigat is surrounded. This is the only issue. Otherwise, rest property we don't have any issue with both of the fathers. Only this is the issue. Now, as per this, under this agreement, I will just take to the relevant portion of it. How the both condition that both the brother was supposed to follow. I'll just
They are
take.
the brothers.
Yeah,
The brothers.
yes, brothers.
Own
Respondent number,
brothers.
respondent number 5. Yes, on brothers. Respondent number 5. So I will just take to the paragraph. Sorry, page 44. This was the terms and condition in the agreement. Page 44.
Yes,
Yes, 9. May I read?
yes.
Both the parties have further agreed to execute another agreement after the final measurement and demarcation of the aforesaid plot of land within the aforesaid time prescribed above. That is one condition. And then 12 is another condition. Both the parties have agreed to execute this deed of amicable partition division of land property before the competent magistrate Pasigat East Siang district, and also to present themselves for registration of same before the sub-register Pasigat East Siang district. This was the terms and conditions. But then, despite of this agreement, the respondent number 5 started erecting the some iron roads in the ancestral land, which was
There is
finally supposed to be demarcated.
connection of this.
Yes, and then what happened?
If I was lodged,
Yes, FIR
so now you have come with quashing of their file.
FIR, even charge sheet also been filed,
Shit, okay.
and then proceeding is happening before the CGM. Well, I also pray that, in fact, the petitioner is studying as a law in Delhi University in the first year. Well, so the issue here is that the property which is divided between the two brothers, which is not yet settled, in fact, especially demarcation. So now question here is that when demarcation is not done, when officially it is not belongs to the his uncle, then there is no issue or trespass. That's my submission here. Trespass and
It's a criminal case. How
yes.
Come with this civil laws in that manner. It's a different issue. That is a demarcation.
But then I want to just show your lordship is that the property which is being disputed between these two persons, the uncle and respondent number 5, it is still in the government records. My lord.
And this is the first day.
Yeah, this is the first time. And another important, I will just take to the legal notice also. Legal notice was also issued by his father. That is also important document. Your lordship may see that one. It's a page 75. Page 75. Because this legal notice was prior to the FIR. Here was 75. 75. It's starting from 74. Your lordship. Starting from 74, but relevant is in page 75. Relevant is page 75. May I just read the relevant paragraph?
75 para?
75. Para D, my lord. It's starting from para D. May I read? It has come to the notice, my client, that you have breached the contract in the following manner. That you have not been forthcoming the final agreements between you and my client regarding the demarcation, measurement, and division of the ancestral movable landed properties. Second, that you have been begin to fix and construct permanent structure on the aforesaid immovable land properties before the execution of family agreement between you and my client. Third, the specific clause which are violated and breached significantly. So because which I have read in the agreement, there's two agreements, 9 and 12. So this was this was issued before the FIR, Your Lordship. And then another important, why this land is still in the possession of grandfather's name. I want to read another letter which was written to Deputy Commissioner by the father of the petitioner. Yes, I will just take to page 87.
87.
87, yes. Yes. 87, he has specifically mentioned the land in issue, married, prayer. Praying for the issue of restraining order in erecting. This is issued by not the petitioner, it is issued by the petitioner's father, the respondent's brother. Married. Prayer for issue of restraining order in erecting permanent structure or any kind of fencing or wall, not to issue any LPC, LOC registration in respect of land in favor of Sri Kaling Dorok, the complainant, in the located place like 5 mile area Tajum. So this is the area. This is Tajum village and then Sibo village. And just may I read the last paragraph, fifth,
Yes.
second last paragraph, may I read? Second last paragraph. It is honorable request that no LPC, LOC registration be done in both the name Tamun and Kaling Dorok, respectively in 5 mile Tajum, Yapko and Sibo area. Sixthly, we had agreed to not to sell out even our sons and daughters landed property with our such and such 28 and such debt clause. No any be registered individually. None will issue NOC for possessing LPC, LOC individually. Land shall remain joint property. And 88 is the last. In the light of above facts, it is to request you kindly necessary order to my younger brother Sri Kaling Dorok, pray above for which I shall be grateful. So this was the letter related to the Deputy Commissioner. But Your Lordship may see this is dated 5th March 2021. 5th March 2021. But whereas in the FIR, in the charge sheet, they say that all the agreement was based and it has declared the finality in that property was clearly divided. If the property was clearly divided, why then this petitioner's father should write letter to the Deputy Commissioner? That is one. Another is also a legal notice was issued by the petitioner's father. So now question here is that that is one. And another, I will just take to the other important. If this property was settled, then why the respondent number 5 should write letter to the neutral body for the local Kebang? I will just also take to that one, that letter. I want to read that one also. 87. 87 also very important because this is all after the lodging of FIR.
87.
87, yes. 87. 87, sorry. It is 87, like, sorry, 90. 90 is the legal note. 90, sorry. 90. 90 is a type copy and 89 is the local language. No, Your Lordship may note the date 3/10/2021.
12/10.
3/10/2021. May I read? On dated 27/7/2021, I received one complaint from your brother Kaling Dorok and a complaint letter with regards to division of ancestral immovable property, transport of armed license and late target rule allowed number such and such. In this regard, Kaling Dorok had made a complaint before me, insists me to call a Kebang. Therefore, I inform you to take Kebang has been fixed on 12/10/2021 Benu, Boeing Mosuk 9. It is a mandatory for both of you to attend the Kebang. So this was if the property was equally demarcated, settled, then why this respondent 5 also should write letter to the Gambura to settle through the Kebang. And that is also 3/10/2021 because in the FIR and the charge sheet, the relied upon was of the agreement of 2010, almost all the agreement of 2010. And one is of 22/1/2021. So this is all after this one. And your lordship, I'll just take another decision of the village level decision. That also will show why this, the land end dispute is not settled. I will also take to that page. Your lordship may take to page 113. 113. Yes, 112 is the local in the local language, and then 113 is a translation. In here, it is clearly mentioned about the land end issue between the two brothers. May I read? The final report of special, in fact, special, when I have shown you, your lordship, I have shown you the notice by the Gamura. After that, this special committee was constituted. And then special committee has come out the report. May I read this one? Final report of special committee submitted to the chairman of Kebang Council mass gathering held in Boeing Village. 31st, this is your lordship may note down, 31st October 2021. On 12/10/2021, case of Sri Tamon Durug, Tasal Village and Sri Kaling Durug, the Kebang which was held at Boeing Moshu held that 9 members committee was constituted to verify and settle the ancestral land disputes and demarcate land between the brothers. Therefore, the committee had submitted its report to the chairman following where the report submitted. 1. Report of committee land located at Yabgo village has verified on dated 7/10/2021 had been submitted. And another, this is important is the second number, your lordship. The land located at Tajum, this is the issue, your lordship. 05 mile Pasigat had settled, report had been submitted. So this was settled only in the 31st October 2021 between the brothers. So now question here is in the chart sheet. I will just take to the chart sheet. Chart sheets, they have relied is of the agreement of 2010. I will just take to the chart sheet. Your lordship may read starting from 114 and then 114 and this 114. 114 in the property which is in the investigation, the IO has annexed the properties. One is the 10/10/2020. Second is that 19/10/2020. Third is that 21/08/2020. And fourth is in 115 is 22/02/2021. So this is all prior to the legal notice, prior to the complaint, but the respondents further to the deputy commissioner mentioning the area Tajum. And this is prior to the final decision of that special committee, which I have read, which was decided on 31st/10/2021. So before the issue land in dispute between the brothers was settled only on 31st/10/2021. So now, my lord, your lordship, my question here is that as per the chart sheet, which is says that he has trespassed the land of the respondent number 5. It doesn't arise, your lordship. Because I just may read the investigation, this one. In the investigation also, they have perused this much document of 10/10/2020, 19/10/2020.
That is why you have filed this petition for quashing of the.
Yes, that's what I have filed.
That's why I can
And-
understand.
Yes, and then
Additional notice after hearing the other side. The order
Yes.
will be passed accordingly.
your lordship also I'm pray for the interim. In fact, this case is pending before the CGM.
Yes, this matter is between the family relationships. So both sections are otherwise compoundable. So notice be issued to the respondent, private respondent.
So you can approach before the trial court also, all these are compoundable.
Compoundable,
offenses.
yes.
447, 341. The civil disputes are between the parties and the case has been arisen on the basis of this settlement and all this thing. Part so and so, so and so. Application 482. CRPC in connection with quashing of, quashing of GR case number 2421 in bracket, Pasig had base case number 21/21 under section 447, 341-506 CRPC. You represent respondent 1, 2, and 3.
Yes,
1, 2, and 3,
and four.
and 4. 1, 2, 3, and 4. Issue notice to the respondent file. The petitioner shall take steps on service of notice to the respondent file with registered ID as well as the usual process, returnable within 4 weeks. As 1 to 4. Granted additional PP has entered the appearance, the formal notice we issued, however, extra copies were furnished to them. Granted additional PP during the course of the day. That is from the submission of learned counsel for the petitioner that. A dispute is prevailing between the parties, the petitioner and the respondent number 5. Regarding their ancestral properties. And the present case arises on the basis of the issue. Regarding the landed properties. In view of the submission of the learned counsel for the petitioner, the further proceeding of GR case number. When the last order,
Yes, it's no
last order passed by
167.
167.
It's on 25/7/2023. The order was passed on 167.
So on that day, the accused, the petitioner was present.
Yes,
in that.
on 25 he was present.
On next day.
Next it is fixed on 25/9.
25/9 for offense explained.
Yes. That's what I pray for the stay of this proceedings.
For the proceeding of GR case number 21/2021. Shall remain state. Till returnable date.
Of life.
Okay.
My lord, in this case, we may require some accommodation, my lord. The CD has not been received as of today.
Which one?
5/6.
Bill,
My lord.
it's a cancellation.
No, my lord, voter care application, my lord.
38.
My lord, in term of my lord, interim order, my lord, I appear before the IO on my lord, 15, my lord, my statement recorded, my lord. Additionally, my lord, on 15, I was up, we are not, for,
CD received, CD is received.
No, my lord. We have sent the WT message, but as of today, we haven't received the CD. So some accommodation may be given to us. We'll.
Next date. Next date.
Next date, my lord, after 1 week, my lord.
For learned counsel for the petitioner, learned additional 50 submits that.
may I say, my lord?
Yes.
My lord, within this 2 week, I have some personal difficulty medical. May I say after 3 weeks, my lord?
3 weeks.
My lord. Medical.
Please for some time to produce the case diary. Read of the petitioner is along. Additional. 50. List the matter on, yes, date.
Yes, after 3 weeks. ma'am. It'll automatically come after break, after it's 3 weeks, my lord.
Vacation,
Yes, my lord. It's 3 weeks.
okay. On the opening day,
6th of November, my lord,
6, 10,
10, my lord. If it's 3 weeks, my lord, after 2 weeks, we have a vacation, my lord. And it'll automatically come by 6th of 10,
6, 10,
6th, 10.
6, 10. For submission of case diary. Till then, interim protection granted to the petitioner is extended.
Obviously. Next item, my lord, is from the same impairment, same order came to pass, my lord.
Which one? Next,
See,
Next
next
item.
item. Item number 6,
item number 6 also.
My lord.
father and son.
Obviously. My lord, it should be 611, my lord, not 16, my lord.
Not 6,
611, my lord.
6, 11.
11, it
10,
has to be 11.
11, my lord.
6, 11.
Obviously.
May I lordship?
Please.
Lordship, this is also a pre-arrest bill. This honorable court by order 59 of 2023 was pleased to grant me pre-arrest bill. Lordship, here the petitioner, that is the alleged accused, had appeared before the IO on,
This CD receipt,
yes.
statement recorded.
Lordship, I have been informed that on 28 and 21st, he had appeared before the IO, but IO has not taken his statement. I have been informed on, and yesterday,
You are the informant.
no, Lordship, I have been informed by the petitioner
Okay.
that he went to police station on 21 or 28 and 21st. On 21st, yesterday, Lordship, accordingly with my colleagues, we went to the police station, but the investigation officer stated that since we came in the police station around 2 o'clock, 2 in the evening,
Statement was not recorded.
not recorded, because accused is non-cooperative, not cooperative.
What?
Accused is not cooperating with the IO. They are saying not. And despite of this court interim orders, accused has failed to appear before IO. It is as per the comment of the IO. That's in its status report. The second para, second page.
You're for the-
Status.
you're for the informant. Informant. You filed another case for.
Negotiation and NIA before CJ.
That is altogether different case, which is not at all connected with this. They are trying to link the case with this present FIR. Absolutely not connected with that. The amount is different.
Amount
Here-
is same, that is one crore and the date of pay as per documents available in the record. Anyway, where is the order, report of IO?
That's why, Lordship, before my submission, I had met by Sten, being an officer of the court, Lordship, as informed by the petitioner, that is the alleged, he had appeared before the IO. Yesterday also, along with my associate, they had gone to the Itanagar police station. But I had refused to take his statement. Lordship, I don't know why the IO is.
As per report of IO, we have not appeared.
Lordship, that's what yesterday I had sent my colleagues, my junior along with the accused to appear before that. They had gone to the Itanagar police station also. But the IO has refused to take his statement. I've been informed that the IO has said once the CD is returned back from the honorable court, he'll take his statement. That is what the IO has stated. Since the statement is not been taken, you're not my praise, 1 more week may be granted to me, Lord. Within 3 or 4 days, Lord, I'll give my statement. I'm ready, Lord. I'm ready to cooperate.
Third learned counsel for the petitioner. Learned additional PP and Mr.
A.K. Singh, Your Worship.
Appearing from respondent two, I think.
Yes.
Not met by party lordship.
Not
I have filed
made-
Wakalat affidavit, sir.
Learned counsel for the informant. Informant. It is submitted by learned counsel for the petitioner that though his junior advocate accompanied the accused petitioner to Itanagar police station for recording his statement as per order of this court, but the investigating officer has refused to record his statement. Why he refused to, though the order of the court is there, why the IO has refused?
That I don't know, lordship, what is the intention of IO also, lordship? Because since lordship, there isn't, this is also a clear civilian dispute case. They are trying to give a criminal clear and
That is
extra,
different issue.
that's one.
It said there is an order of court, so you have to record the statement. Whether right or
Wrong, that-
other bill, that is.
Lordship, within 2-3 days, I'll make an, I'll appear before the IO again. And lordship, and order
I'm
maybe.
free for,
Mm.
I'm praised for 7 days time. To further appear before the IO for recording the statement. On the other hand, under additional PP has submitted that and produced the case diary. From which it reveals that. The petitioner has failed to appear and join the investigation. However, the petitioner is directed to appear before the investigating officer within 7 days from today, positively. Otherwise, the interim order granted to the petitioner will be cancelled automatically. So this the matter, call for the up-to-date test diary on will be the date,
7 days.
7 days, 20 to 29. 29/9. Additional PP is to produce the case diary
30.
along with the
30 Saturday.
30 Saturday,
30 Saturday, then 29.
29, that's 20. 29.
With the up-to-date test diary along with the statement of the accused.
Deeply obliged.
Yeah, please. Lordship, I have taken consent from my friend. Taken after 2 weeks.
After. Yeah, for the petitioner.
I'm for the petition. Most obliged.
My lord, your step was taken upon the sole respondent, but the service is still awaited. May I pray, my lord, I may be allowed to take fresh steps.
You have taken steps, no?
Yes. But it's still awaited, so I may be allowed to take fresh steps, ma'am.
Fresh steps.
Fresh steps, ma'am.
Pardon, sir. To learn counsel for the petitioner. And praise to the fresh steps taken to respond and respond, so respond, no?
Sole respondent.
Respond. The petitioner shall take steps and service of notice to the respondents with registered daily as well as usual process written within 4 days. Steps to take taken within 3 days. List the matter after 4 weeks.
There's an
Interim.
interim.
Interim is extended.
Okay.